Straight ahead on Law and Crime Daily. Could movie director Woody Allen still be prosecuted for child sex crimes? Our experts discuss the latest in the allegations by Dylan Farrow after the HBO series Allen vs. Farrow. And should a convicted killer owe the victim's family thousands of dollars? The restitution hearing in the Michelle Martinko case, Murdered at the Mall by Jerry Burns. Plus, strikes and dismissals as questioning of prospective jurors in the Derek Chauvin trial continues. Should the jury hear about George Floyd's previous arrest? Our guest. Welcome everyone to Law and Crime Daily. I'm Brian Buckmire along with Terri Austin. The panel of jurors to serve on the Derek Chauvin trial is starting to fill up as we near the start of testimony in the George Floyd case. Law and Crime's Kim Johnson is in Minneapolis and has the latest on jury selection.
Brian, it's been a slower day when it comes to selecting a jury in the trial of Derek Chauvin, one of strikes and dismissals. Earlier, 4 potential jurors were dismissed in less than 2 hours. Now, the strikes come from the defense, which has used 11 of its 15 strikes, with 9 jurors seated, 5 more needed. Now, the defense's second strike of the day was against a man who has served in the military and had been trained in hand-to-hand combat and chokeholds. Here is the defense attorney, Eric Nelson, grilling him about that. Take a listen.
And as a part of your military experience, you had training in hand-to-hand combat and chokeholds and things of that nature.
That's correct.
And would you be able to kind of abandon your prior personal experience and apply what is trained by the Minneapolis Police Department?
I'm able to understand what someone else's training is and apply that to the circumstances that they're in, if that's what you're asking.
Jury selection continues Wednesday. This as defense's request to delay and move the trial to another location still hangs in the balance. The judge said that he would consider the motion given last week's major announcement of a $27 million settlement from the city of Minneapolis to George Floyd's family. Now, Judge Peter Cahill also today said that he plans to bring back the 7 jurors that were selected last week for re-questioning. This after news of that settlement on Friday was announced. He wants to ask those jurors on Wednesday if they heard about that settlement and if it has influenced their opinions of this case. Brian?
Thanks, Kim. And jury selection is continuing on as the judge is considering a motion to both delay the trial and move it to another county after news broke of a $27 million settlement between the city of Minneapolis and George Floyd's family.
There was an article in the Washington Post that was published on March 12th of 2021, wherein the Washington Post reports that a Minneapolis official said the city had been concerned that this announcement could affect the trial. The official, who was not authorized to speak publicly, said the city consulted with Hennepin County Chief District Judge Todrick Barnett, who told the city it could proceed. Barnett did not immediately respond to a request for comment. I do think it's question of who made this decision to announce this. So.
And I think the bottom line is this is a federal lawsuit. This court was not involved. And as I recall in my discussions with Judge Barnett, the answer was, we can't tell you what to do. And I think he expressed the concern that we would have about doing such a thing in the middle of jury selection. So there was no approval by this court. We had no authority to approve any release at this time.
I just simply am making a record.
I think the city is trying to dump their responsibility back in the court where it does not belong.
Joining us today to break down jury selection in the trial against Derek Chauvin is criminal defense attorney Nicole DeBoard and Terri Austin. Nicole, this motion to delay and change venue is still hanging over the case. I think the train has kind of left the station and the judge will just move forward to start, but what do you think?
I agree with you. And I think the judge's remedy is smart from an appellate standpoint as well, in that the judge is saying, you know, look, I'll let you go back and talk to these same jurors that you've already selected again, just to make sure that this new settlement hasn't impacted their feelings about the case in any way. But I don't believe that at this point this judge is going to stop this trial and delay it any further.
Yeah, I think the judge is smart to kind of conceive or think about the appellate issues here. Terri, oftentimes when we pick a jury, we're thinking about race and gender. They're always the focal point of jury selection. But one thing that stuck out to me is the age. Most of the jury is in their 20s or 30s. How do you see that playing out during the trial?
Well,
You know,
you
I think
raise an interesting point. I think the fact that the jury pool is on the younger side, at least 7 of the 9 jurors are in their 20s or 30s, which is quite unusual. And I think that this could work against Chauvin, if you ask me, because presumably these younger jurors, they may have a greater affinity for causes like the Black Lives Matter cause. So I think the real important issue at the end of the day is whether or not these younger juries are going to be able to speak their mind and have influence over the older jurors.
Nicole, real quick, your thoughts about the age of the jury?
I totally agree with Terri. I mean, the reality is that this is a generation that has come up with an appreciation for social justice causes. And, you know, they're going to have a different perspective than older jurors might, who would be coming down to hear this case.
Yeah, and again, I think the other 2 jurors that we're talking about, I believe, are in their 50s. So you've got, like Terri said, 7 of the 9 in their 30s or 20s, and 2 of the 9 in their 50s. It's going to be an interesting breakdown. Still ahead on Law and Crime Daily, Jerry Burns, convicted killer of Michelle. We're back. Derek Chauvin's attorney wants the jury to hear about an arrest of George Floyd a year before he died. Law and Crime's Angenette Levy is here with the arguments from both sides.
Yeah, Brian, Derek Chauvin's lawyer says that George Floyd's behavior during that 2019 arrest shows a clear MO by him when he encounters police. But prosecutors say the defense simply wants to use this prior arrest to smear George Floyd.
41, Trevor.
May 6, 2019, Minneapolis police body camera video shows officers confronting George Floyd in the passenger seat of a vehicle.
Keep your hands where I can see them.
Derek Chauvin's lawyer says Floyd's behavior shows a pattern of using diversions such as crying.
Tell what you got. I'm going to tase you.
And swallowing pills when approached by police. Judge Cahill had already ruled the jury wouldn't hear about the arrest.
Even if it's a modus operandi, that is how George Floyd acted when he was confronted by the police, it really isn't relevant. These are different police officers.
The similarities are incredible. I mean, it's the exact same behavior in 2 incidents, almost exactly 1 year apart.
Chauvin's attorney says things have changed since the prior ruling, after a second search of the squad car earlier this year, where Chauvin's defense team found chewed-up pills with Floyd's DNA on them.
It's just kind of mind-boggling that an extensive search was not done until January 2021.
The May 2019 body camera video shows officers finding pills in a bag owned by Floyd. Floyd is taken to a police precinct where paramedics are called because Floyd has swallowed those pills.
You've got a person who is being specifically told this behavior, or presumably this behavior, is putting you at risk of having a heart attack or a stroke.
The state again objected to the jury seeing the 2019 arrest video, calling it prejudicial.
I think the attempted reliance on habit tells us a lot about the real motivations behind this. The desperation of the defense to just sort of smear Mr. Floyd's character by showing that, what he struggled with, an opioid addiction like so many Americans do. The issues in this case are the objective reasonableness of the officer's conduct in the way they handled Mr. Floyd, whether he has hypertension.
The officers have to deal with their person, their arrestee, as they find them, whether it's May 6, 2019 or May 25th, 2020. Emotional state feigned or emotional state genuine.
Now, the defense attorney says that this supports his claim that interaction with the paramedics and the discussion about a heart problem supports the defense claim that George Floyd actually died of a heart attack or possibly even a stroke. Judge Cahill said he will take this whole issue under advisement. He said there may be a portion of this tape that could potentially be relevant. It may be that interaction with the paramedics, but he has not made a final decision just yet. Brian?
Thanks, Angenette. Here to break down the latest argument by the defense is criminal defense attorney Nicole DeBoard and Terri Austin. As I understand it, you can't use the previous arrest because the ultimate question, as I think was kind of pointed out there, is what Chauvin knew or his intent, not basically what Floyd did in the past or did in the past. And so to bring up this video, I don't see how it works, but we'll see how this works. Terri, what do you think the value of the arrest is, and should it come in?
Well, I don't think it should come in. And I've got to tell you, I think Eric Nelson is really arguing strongly on behalf of his client, Chauvin. He's trying to say, you know, it's a common scheme, that this is his habit. There's an absence of mistake. But the judge did not allow it before, even though Eric Nelson said that this was identical and that it shows how George Floyd uses these illegal substances. I think if it gets in, it's only going to be on a limited basis, and it's going to be because there might be some probative value and the fact that it might not be too prejudicial. But I think the judge is going to stick to his original ruling and maybe keep it out.
All right, so Nicole, the judge is kind of saying maybe, we'll see. So is there any way that this 2019 arrest comes in?
I think that Terri has really boiled it down to exactly what Nelson is arguing in terms of, you know, look, I'm not trying to talk about his prior criminal conduct. I'm trying to talk about how this might be more likely that he died of some other cause besides at the knee of Chauvin. He's trying to say that there may have been a medical reason that caused his death that is unrelated to Chauvin's conduct. And, you know, portions of the video in terms of an encounter could be potentially admitted to show that this type of thing had happened with him in the past.
It'll be interesting to see how that argument plays out. I can see a judge saying, well, don't you just want the medical examiner's report to find that? But we'll see. Angenette, the prosecution said there is a key difference in the video from that of the May 2019 to that of the May 2020 video. So what is it?
Yeah, the prosecution, you know, and the defense, I think they can agree in both videos. George Floyd is being contacted by police. He's being taken into custody. In both instances, he ingested pills. So that was very clear. However, in the May 2019 arrest, the paramedics were called and he received treatment. He was monitored. They told him, look, you know, you're really putting yourself at risk for some serious health issues doing things like this. They monitored him, and he didn't even need anything to reverse an overdose or anything like that, and he survived that encounter.
Yeah, and the thing that I would be afraid of as a defense attorney, the one major difference in the 2019 case is there was no knee on George Floyd's neck. He swallowed drugs on both of them, but on one of those occasions, he didn't die. So this could potentially backfire on the defense, but we'll see how it plays out. Coming up on Law&Crime Daily, accusations against Woody. Welcome back. An Iowa man convicted in 1979, murder turned cold case, no longer owes the victim's family tens of thousands of dollars. Prosecutors in Cedar Rapids say Jerry Burns killed then 18-year-old Michelle Martinko when Burns was 25. The 40-year-old case languished until DNA tests were invented and public genealogy databases became weapons for law enforcement. Burns was found guilty of first-degree murder last year, sentenced to life in prison, and ordered to pay the Martinko family $150,000. But Burns' defense says that since Iowa's victim restitution law did not exist when the murder occurred decades ago, he should not have to pay.
The state and defense counsel have reached consensus that it's inappropriate to apply the $150,000 restitution in this case because it would be, an ex post facto application of Iowa's restitution laws against Mr. Burns. So first, I'd just like to ask for the court's guidance as to whether the court would like us to officially file a motion to correct illegal sentence.
I will prepare an order correcting that portion of the sentencing order, and I will cite in there. Well, I don't think there's any question. If there is an illegal sentence, the court may correct it on motion or on its own motion at any time. So I will correct that portion of the dispositional order to remove the order directing payment of $150,000 to the heirs of Michelle Martinko.
Here to discuss restitution for convicted murderer Jerry Burns is criminal defense attorney Nicole DeBoard and co-host Terri Austin. Nicole, no restitution, because from what I understand, the law didn't exist when the crime occurred, basically ex post factos. Is that basically it, and is that correct?
I think it is correct. And even though it strikes us all as very unfair, I mean, obviously this person's been found guilty of the crime and there is now a provision allowing for restitution. The problem is that the law at the time of the crime did not give a defendant warning that such a punishment or restitution could be required. So the judge just has to follow the law as much as it does seem painful and unfair.
Yeah, you've got to be at least aware of the punishment or the potential punishment when the crime has occurred. Terri, without the restitution, though, do you still think that the case ended the way it was supposed to? Was justice found, basically?
Well, we got some justice because we did have a conviction of the individual who murdered Michelle Martinko. But I think that the family definitely deserves some restitution here. There was quite a bit, obviously, of pain and suffering here. And even though it cannot be applied retroactively, I do think that the family has some, consolence in the fact that they have a conviction. At the end of the day, though, the restitution would not make any difference at all whatsoever. It is not going to bring this young girl back.
Exactly. And I mean, real quick, Terri, could there potentially be a civil case? Could they seek damages there?
Yeah, they could do that. I mean, we will see what happens, but they could file a claim. They could for wrongful death. I mean, that's always a possibility. So we'll see if that happens. At this point, it doesn't look like it will.
Yeah, we'll keep eyes on that, and maybe they do have the possibility of getting that civil claim and maybe getting something from Jerry Burns. Thank you. When we come back, Allen versus Farrow. The decades-old saga gets new attention, what that means for alleged victim Dylan Farrow, and is there still a possibility of prosecution? Our legal analysis after the break. Welcome back. The HBO docu-series Allen v. Farrow is bringing the spotlight back on the decades-old case involving two famous celebrities and sexual assault allegations. Terri Austin has been following the saga and is now looking into the question, could Woody Allen still be prosecuted?
Mia Farrow first accused Woody Allen of molesting her 7-year-old daughter, Dylan, in 1992. Allen denies any wrongdoing, and police say they could not find any evidence of an assault. But that doesn't necessarily mean it's case closed. Allen and Farrow adopted Dylan and raised her together until the couple's separation. A videotape surfaced of Dylan describing Allen sexually. Allen claims Farrow coached young Dylan to say those things because of his romantic relationship with Farrow's college-age adoptive daughter, Sunyoon Previn. The Lynchville County, Connecticut prosecutor investigated Dylan's claims. He explains in Allen v. Farrow that he strongly believed there had been probable cause to bring charges against Allen, but he chose not to in order to protect the girl from further traumatization.
The option was clear. Have Allen arrested, go to trial, and put the child on the stand as my first witness. But was it truly in her best interest?
Could you give us a comment, Woody?
There was incentive to be drawn into efforts to discredit my sister.
This is a calculated move in a media war.
I was so scared. I didn't know what would happen next.
So Terri, walk us through this. What options are still on the table?
Well, Brian, there are no statute of limitations for most sex crimes against children in Connecticut. So theoretically, even though the alleged sexual assault occurred in August of 1992, the victim can still bring criminal charges against Woody Allen today. In fact, Dylan could even file a civil claim for personal injury caused by the sexual assault because she was under the age of 18 at the time of the assault. The real question is whether Dylan will recall the details of an event which occurred almost 30 years ago.
Nicole, let's bring you in to discuss. As a former prosecutor, do you see a sitting state's attorney reopening the case?
I think it's quite possible in this circumstance. I mean, certainly there's been a lot of information that is now accessible that wasn't previously available to the prosecutor before. You have a witness who is in a position to be able to tell the prosecutor whether or not she remembers or doesn't remember and whether or not she's going to participate in a trial, which is a much different thing than what you have sometimes when you have a young child who may or may not be able to testify.
Yeah, and Terri, I'm not just seeing a potential reopening of the case, like the criminal case, but what about all those who are tasked with finding justice for abused children who turned a blind eye? Could there be litigation there?
No question about it, especially as far as the state of Connecticut is concerned. This all happened in the state of Connecticut. And while they did some investigations, they ultimately decided that there was no reason to move forward here. And even New York could have done something. They were looking at the divorce case. They were looking at child custody issues. But they had some inkling that something was going on here. And you have to think that because it was Woody Allen, because it was such a high profile case, that maybe everyone ultimately turned a blind eye to what was going on here and just allowed it to continue forward, which really means, as far as I'm concerned, there could be some cause of action against both of the states for failing to do something on behalf of these children.
Yeah, and Nicole, real quick to both of your points, I mean, this was pre-Harvey Weinstein when you didn't think you could take down a giant like this. Do you think that now, in 2021, there may be more of an inclination to go forward on Woody Allen's potential charges?
I think that's a great point. I think that it's entirely possible that because people are more willing to listen to sort of both sides in the testimony, even about something so awful as child abuse, or sexual assault in court, the perspective is going to be different. And a prosecutor may feel that they have a better opportunity to get someone to give this case a fair listen.
And thank you for joining us here. We'll see you next time as we discuss justice in America.